In this segment, we will be discussing one of the most important problems in comparative constitutional law, which is which jurisdictions do I choose to compare? While choosing jurisdictions to compare, judges are largely faced with two big questions. The first, which jurisdictions do I compare? The second, do I accord equal weight to all the jurisdictions that I have chosen? This is a question that can be answered at two levels, one at the level of constitutional theory and the other at the level of institutional constraints. So, what are the practical challenges facing the judge who is engaged in this project? There are obviously limitations to looking at this only from the perspective of a judge. So the protagonist of this particular segment is a judge of the Constitutional Court, but it could very well be a member of a parliamentary committee, a member of a constituent assembly engaged in drafting a new constitution, or even a legislature. But we are, for the moment, not concerned with those with those positions. We're only concerned with the particular challenges facing a judge of a constitutional court. Um, so, to sort of expand upon this point, I have laid out three different angles at which to look at this problem. The first I call judicial motivation. The second, institutional constraints. And the third is what I have titled a question of quantity, which goes back to the second big question that I asked. Do I accord equal weight to all the jurisdictions that I have chosen by looking at which jurisdictions you in fact actually choose? So let's go ahead and look at the first question, which is judicial motivation. To understand the problem of judicial motivation, I largely draw upon Sujit Chaudhry's theory of comparative constitutional interpretation. The first question that sort of faces a judge engaged in the project of constitutional interpretation is what motivates a judge to actually turn to comparative law or to international legal materials in order to quote unquote solve the problem at hand. This is largely dictated by the way in which the judge or the bench frames the question as a constitutional issue. It could be about the way in which a right ought to be constitutionalized, or it could be about an existing right in the Constitution. Or it could be about something that's entirely not rights based at all, but still finds a place in the Constitution, such as presidential powers or the Constitution of the Parliament, and so on and so forth. So, now that we've understood what judicial motivation means, there are three different ways in which judges might proceed. The first and the most logical one seems to be that they would pick cases in which similar issues were at hand. Um, so this could either be theoretically or practically addressing cases that address the same issue theoretically or practically. Second, they may go on to pick jurisdiction where the constitutional text looks similar or bears the greatest similarity, because this would have, for instance, yielded the same kind of case law or involved judges in different jurisdictions adopting similar methods of interpretation. And this sort of makes it easier for a judge looking at other jurisdictions to say, hey, that's something that I can perhaps learn from. And the third is one in which they, for practical or strategic purposes, they choose a model which they think, or an interpretation that they think could add value to the interpretation that they themselves have sort of decided upon. And this choice is at the theoretical or at the very inception is the one that shapes the problem of which jurisdictions to choose. I've given a small example in the accompanying text, which is that of a jurisdiction X, in which there is no right to health in the text of the Constitution, whereas jurisdiction Y includes the right to health in the constitutional text, and there's a third jurisdiction Z, in which the Supreme Court has crafted a right to health through a series of judgments. But it actually does not appear in the constitutional text. So just to recap, we are concerned with the judge in the Constitutional Court of Jurisdiction X, who has at this point two options: a jurisdiction Y, whose constitution contains a right to health in the text of the Constitution, and a jurisdiction Z, where the Supreme Court of that particular jurisdiction has crafted a right to health through a series of judgments. Now, what is the choice facing this particular judge in jurisdiction X, the first jurisdiction? If the judges in jurisdiction X choose the first model, that is, that they look at cases which bear the greatest similarity theoretically to the issue at hand here, so the right to health in jurisdiction X, they may choose to compare X with Y or Z or both. Assume in a different situation that there is a fourth jurisdiction P, where P's Supreme Court has ruled that the right to life in its constitution includes the right to health. This is obviously drawn from the example of the Indian Supreme Court. If P's interpretation of the right to health bears a reasoning or context very similar to the one that the judges in X prefer, they may choose P as a comparative study rather than or in addition to Y or Z. So there are sort of two big takeaways from this example, right? That for a judge who is engaged in the enterprise of comparative constitutional law, there are very many different ways in which they may draw upon comparative materials, and this largely goes to the question of judicial motivation. Is the judge persuaded by or attached? Does he attach greater authority to a constitutional text? Does she attach greater authority to a sort of to the reasons given for this particular constitutional interpretation? So that really determines the way in which judges proceed with choosing particular jurisdictions. So just to recap this section, we are looking at the question of judicial motivation as one of the three big questions that are involved when a judge chooses a jurisdiction. So in this particular case, judicial motivation is really about how a judge chooses a jurisdiction, drawing from the way in which his or her own court has chosen to frame the issue as a constitutional one. So moving on to the second big question, which is that of institutional constraints. What do I mean by institutional constraints? So this largely goes to the practical challenges facing a judge who is engaged in the enterprise of comparative constitutional law. So whichever one of the judicial motivations the judge possesses, there are certain practical challenges that face this judge. So it could be something as simple, but deeply problematic, like the problem of being literate in more than one system. This could be a question of education, it could be a question of language skills, it could be the difference between the procedural differences between common and civil law systems. It could be any number of things that are sort of that operate at a very sort of practical level. But at a more theoretical level, The project of comparison also assumes that there is a way in which judges can extrapolate a certain kind of best practice by looking at the ways in which institutions have dealt with those particular legal problems. Is there a version of a normative good that is universally or globally acceptable that judges can sort of draw on and use in their own constitutional interpretation? So these are some of the questions that operate at a very practical level. But apart from these general problems that face any scholar of comparative law, there are certain particular challenges that face the student of comparative constitutional law. And I highlight two of them uh, here. The first one is the historical context, and the second one is what I refer to as expressivism. So let's understand the first one, which is the historical context. One of the things that makes it easier at a practical level to compare constitutional interpretations is the historical context. For instance, the US and Indian constitutions were written as revolutionary constitutions, overthrowing a colonial power. So the historical context in which those constitutions emerged are similar, if not the same. Other examples include Latin American constitutions written in the 1980s and 1990s, which mark a transition from authoritarian to democratic regimes. But there are others, like the Basic Law of Israel, where there were no political shifts that accompanied the writing of constitutions. So, logically, it stands to reason that if you look at jurisdictions that have similar historical contexts, that they are easier to compare, because the possibilities of finding interpretations of provisions that have similar values or similar motivations are greater than in other cases. So, for instance, it might be easier to compare India and Pakistan rather than, say, India and the US. But of course, given India and Latin America, it might be easier to compare India and the US. So, this is what I mean by looking at the historical context as one practical challenge which might be faced by judges. The second point that I wanted to make here is that of expressivism. So, some of the provisions in a constitutional text are not functional. So, for instance, what I mean by functional is describing the procedure for a writ remedy, for instance, and they may not go to the question of constitutional structures, for instance, what would be the composition of the parliament. Rather, these provisions are expressive. Um, for instance, look at the provision on the abolition of untouchability in the Indian Constitution. This is an effort by the Indian Constitution to reflect its particular aspiration to eradicate casteism. Another example is that of the German Basic Law, which contains what is called the Eternity Clause, which was put in place after the Second World War to prevent easy amendment of the integral provisions of their constitution. Now, these are provisions which are peculiar to these particular constitutional cultures, and these resist easy comparison with other jurisdiction. And this probably makes it much harder practically to draw upon similar kinds of constitutional interpretation. So in this section, I've highlighted two practical challenges, one that makes the project of comparison easier and one that makes the project of comparison harder. To recap, we have just looked at the question of institutional constraints, which is basically about the practical challenges that face judges of constitutional courts while they are engaged in the question of choosing jurisdictions. Finally, we come to the question of quantity, which in some cases might be considered as yet another aspect or yet another practical challenge that judges face. So the third question is essentially this. How many examples do I choose? Do I choose as many as I can? Do I choose one? In some ways, this goes back to the question of judicial motivation as well. And as you can see, the three major questions are clearly interlinked. So one of the motivations for a judge, as Vicky Jackson, a prominent scholar of comparative constitutional law, has argued, one of the motivations for a judge to cite to foreign law is to point to a best practice amongst nations. So if you have to show that there is a best practice, it would be much more desirable to argue that there are more nations engaged in this practice than to say that there are less. So theoretically, a judge ought to cite to as many foreign jurisdictions as possible. But of course, there are even at the level of theory, apart from obviously the practical problems involved in this formulation, there are sort of at the level of theory many other problems. Most famously, the problem of case selection was posed by Rand Herschel by asking what kind of methodology does the judge follow in choosing jurisdictions which he or she wants to compare. Does the judge adopt a historian's approach? For instance, when I referred to earlier that it is easier to compare jurisdictions that have similar historical contexts, this sort of assumes that the judge is literate or interested in pursuing the historical trajectory of that particular constitutional culture. Does the judge become a political scientist, looking for causal factors or drawing up different kinds of research designs? In each of these cases, scholars have largely come to the conclusion that it is preferable that there be rigorous research methodologies that have to be followed before the project of comparison can effectively be carried out. Herschel's point is largely directed at legal academics rather than judges, limited by time, limited by research materials available to them, and so on. And so that is a real problem when it comes to the problem to the judge in a constitutional court. And it's worth thinking about the intersection between legal academics, so comparative legal scholars, and the judge of the constitutional court who has limited time and resources at hand to address these particular questions. And finally, I wanted to sort of look at what I see as a limiting point in the question of choosing jurisdiction, which is the problem of regional constitutionalism. In the sort of examples that we followed in the previous segments, we assume that constitutions are written for nation states. This may not always be the case. Constitutions may also be imagined for regions. The most prominent example in this regard is obviously that of the European Union. So national constitutions in the European Union are measured against the regional standards or practices through judicial review. So there's often a constitutional review at the level of the region in addition to the constitutional review at the level of the nation state. In some cases, this constitutional culture is created, even if the region does not pre-exist that particular constitution. But in some cases, the constitutional culture um, builds up to motivations to provide a regional constitution. Should this constitution exist as a text? Should it exist as a network amongst the constitutional courts in the region, and so on? Is a really interesting question that we might sort of think about in this regard. So I thought it would be useful for us to think about the case of South Asia. There is no common constitution for the region, but India is not only the biggest geographical entity or geographical nation state in the region, but it's also the predominant exporter in comparative constitutional law. So, questions or issues in constitutional law, such as the basic structure doctrine or secularism, have circulated between the countries in South Asia. Uh, if you are a historian of Indian constitutional law, you might see how in the earliest days of the Indian Supreme Court in the 1950s, a lot of the comparisons were to England or to the United States. And as the Supreme Court sort of builds up its own jurisprudence, it borrows from a number of different other jurisdictions. Similarly, you might look at the courts in Bangladesh and Sri Lanka, who cite to the Indian Supreme Court's jurisprudence, especially after the 1980s, where the Indian Supreme Court sort of generates its very peculiar brand of rights-based case law. In addition to looking at case law or legal doctrine, within regions there's also frequent, if not adequate, exchange of constitutional ideas through formal and informal networks of legal professionals or judges, and so on and so forth. So South Asia, in some ways, is an interesting but puzzling example. This is a bunch of countries that shared a British colonial past, and their constitutions were drafted by men and women who shared similar anti-colonial ideals. And in some ways, comparative constitutional in South Asia ought to be much more developed, both at the level of theory and at the level of the practice of constitutional law in courts and in other cases. So if there is a court in South Asia, a constitutional court in South Asia that wants to pick jurisdictions to compare, then its instinct in some ways should be to turn to South Asia before comparing to England or the United States or other Western liberal democracies. But this is often not the case. So one very interesting thing to think about in this context of choosing jurisdictions is the question of geographical proximity, in addition to all of the different theoretical and practical challenges that we have discussed. So to summarize what we have learned in this segment, the idea behind looking at the question of comparative constitutional law from the perspective of the jurisdictions involved in that practice is threefold. One, to understand the theory and practice of choosing jurisdictions for comparative study, to examine some of the biggest debates in the field, and to sort of think about comparative constitutional law not only as a matter of legal doctrine, but as an interdisciplinary subject. Now, how did we go about sort of looking at these issues? So, to understand the theory and practice of choosing jurisdictions, we looked at the major questions in choosing jurisdictions from three different perspectives. One is the question of judicial motivation. How does the judge proceed to pick jurisdictions once a constitutional issue has been framed in the case that he or she has at hand. The second, by looking at it from the point of view of institutional constraints. What are the practical challenges that might make the project of comparison easier or more difficult once a judge has decided how he or she is going to proceed with the project of comparison. And third, we looked at the theoretical and practical challenges involved in looking at which jurisdictions do I pick? How do I eliminate the problem of cherry picking, i.e., sort of being faced with the charge that I just picked the jurisdictions that I liked? And we moved on to looking at the major debates in the field in each of these three different cases. In the first question that we addressed, that of judicial motivation, we looked, for instance, at Sujit Chaudhary's theory of comparative constitutional interpretation and highlighting how judges might choose to either choose similar cases, choose different cases, or choose interpretations which they think may add value to the thing that they are trying to study with the case at hand. In the second case, that of institutional constraints, we looked at Vicky Jackson's seminal essay, which addressed the problem of identifying a best practice amongst nations, and what are the sort of practical challenges involved when a judge tries to extrapolate what he or she sees as a good interpretation to compare to. And finally, we looked at the question of quantity and Rand Herschel's formulation of the question of quantity as a problem of case selection in comparative constitutional law. In this segment, we also looked at the problem of research design and how legal academics and judges may have to work together in order to build up a robust research methodology for comparative constitutional law. And finally, we looked at many of the possibilities for exploring comparative constitutional law as an interdisciplinary subject. So, for instance, when we were discussing the practical challenges that judges face, we imagined that judges would have trouble maybe tracking the cultural context sufficiently or understanding the historical reasons for the ways in which particular constitutional texts have been framed. In many cases, judges might have problems understanding, as well as political scientists do, about the question of causal factors. And in many cases, interdisciplinarity in comparative constitutional law should be largely carried out by legal academics. But this is also a call for us to argue for greater synergies between the legal academy and the practice of constitutional law in courts. And finally, we briefly explored the problem of regional constitutionalism, that in many cases acts as a limiting example or a limiting case for some of the propositions that we have discussed, which is that in addition to the moral or ethical questions that the judge faces that motivates him or her to choose a particular jurisdiction, in addition to some of the practical challenges comparative constitutional scholars face in terms of being literate in particular jurisdictions that are not their own. In many cases, the question of geography also plays in. And that's just an interesting way for us to think about both theoretically and at the level of practice as to what we should be or what we should be considering as an important factor in choosing jurisdictions. Um, some of the questions that we might be asking ourselves at this point, drawn from the discussions we've had so far, is one is whether a judge can adopt more than one model of comparative constitutional interpretation within the context of a single constitutional issue. So, how would that work? We might go back to the example of the right to health that we discussed in the first segment. The second question is something that we might use to sort of extend our understanding, but that hasn't really formed the bulk of this module, which is to look at the idea of the comparativist not as that of a judge, but as someone outside of a courtroom, but someone who still works with legal materials within institutions. So I'm thinking of the Law Commission in India, or a special parliamentary committee sort of charged with drafting a new legislation. How would they face the same constraints, if they would at all, or would they be much more um, at liberty to choose materials that they want? How would a research design for them look like? Um, Another question that we might look at from the point of view of expertise or interdisciplinarity is to imagine a judge faced with medical scientific research in the context of a foreign judgment on the right to health. How does a judge step up and evaluate the evidence provided in, say, a foreign judgment's um, reasons for establishing a right to health? How often should, say, our judge in jurisdiction X cite to the evidence of the judge in jurisdiction Y or P or so on? If you ignore this evidence and you just cite the proposition, what are the risks that a judge runs? These are questions that we might ask ourselves, because they really make us think about the limits of certain kinds of constitutional theory. And with that, we conclude our learning of this module.